Good morning, everyone. My name is Kevin McKenna. I am the Head of Employment and a partner at Kuits Solicitors. It's good to be able to welcome you to the December edition of our HR Breakfast, which now, at least for now, remain as webinars. We've got three speakers for you today. There's myself, Jake McManus, and Claire Treacy. And if I just take you through our agenda, I'll talk to you quickly about ways to connect with us as a business and some housekeeping. Then I'll talk to you about things to look out for in 2023, or in fact some things to look out for a bit sooner than that in 2022. Jake will take us through the usual case law update, and then Claire Treacy will finish with the HR hotspot, where she'll be talking to us about redundancy. Sadly for many, a time of year or a point in the economy where there are a lot more redundancies being made. There's a slide that sets out all the details of how you can stay in touch with us. I'm not going to labour all of that. We'll be sending you the slides following the presentation. If you've got questions, ask your questions as you go along. You'll see that there's a Q&A button on the on Zoom. We won't deal with them as they come up, but if we've got time, then we'll deal with them at the end. As I mentioned, there'll be a follow-up email to you all sending you the slides, so you don't need to take copious notes, although you can. So you'll get a copy of the slides in a follow-up afterwards. So I'm going to talk to you about what's in the pipeline, and there's quite a lot. Clearly, government time has been used with lots of other issues because of the COVID crisis, and so there is quite a backlog of legislation that's on its way to you all. So let me crack on with that, because I think there are about 15 or 16 bullet points for me to take you through, and I'm going to try and do that in about 15 minutes. So the first thing is exclusivity clauses have been banned in contracts for low workers. The government have decided to extend the ban on exclusivity contracts, exclusivity clauses to workers where the worker's guaranteed weekly income is below or equivalent to the lower earnings limit. So that's currently £123 per week. And that will bring those contracts in line with 0 hours contracts. That's a change which is already effective. It came into effect on Monday of this week. Next, there are two ICO consultations to make you aware of that are due to close. The first on the 11th of January, and then the second on the 26th of January. The first is about guidance on the monitoring of employees at work. So a growing issue as more people are working from home and continuing to work from home. And the second, which closes just a week later than that, covers key topics such as the lawful basis for processing health data, data minimisation, transparency and retention. As a firm, we regularly respond to government consultations, and so if that's something that you want to engage with us about so that we can help respond on your behalf, then please do. Also, as a useful tip, I think there's lots of really useful information on the ICO website, and they've indicated that there are plans to publish additional practical tools such as checklists alongside these changes. Next up, the rates for statutory maternity pay, paternity pay, adoption pay, shared parental pay, bereavement leave, maternity allowance will all increase from April. Figures are on the slide there for you. Likewise, you'll see increases in the rate for sick pay from £99.35 a week to £109.40, and that change will come into effect from April 2023. Likewise, all of the changes in relation to the minimum and national living wage for the various age groups. And again, I won't labour those, you've got them there, and the slides will come to you in due course. Next, we've got a series of pieces of legislation which are working their way towards being on the statute books and being in force. And we'll start with the retained EU law revocation and reform bill 2022-23. It's a bill that comes into effect at the end of 23. It has a transition period of up to mid-2026. It's part of the whole the sort of Brexit package, and it will, in practical terms, abolish the principle of the supremacy of EU law. So that will no longer be effectively at the top of the tree, and it will establish a new priority rule that requires retained EU legislation to be interpreted and applied consistently with domestic legislation. It repeals any remaining directly effective EU law rights and obligations, abolishes the general principles of EU law, and it facilitates domestic courts, departing from retained case law. Probably the biggest areas of impact are likely to be in those EU law areas of working time regulations, agency worker regulations, fixed-term employee regulations, part-time worker regulations, and TUPE regulations. So we may well see some changes there. Then on to some other bills which are working their way through the legislative process. First, I'll mention the Worker Protection Amendments of Equality Act 2010 bill. This will introduce an employer's liability for the harassment of their staff by third parties. So that could be clients or suppliers or members of the public. And the bill would require employers to proactively prevent sexual harassment of their staff in the course of their work. So supposed to put that in a meaningful context. You know, the most obvious example for me might be if you work in a bar or you've got employees who work in a bar and they are harassed by customers, even though you're maybe not already legally responsible for the actions of those customers, this will actually make a shift in those responsibilities on the employer. And it will also provide for a compensation uplift in sexual harassment cases where there's been a breach of the employer duty. So the government's committed to make that change in response. It was in response to a consultation in July 2021. It's reached its third reading, or no, it will be due to have its third reading in the Commons, so almost at the end of being passed as legislation on the 3rd of February 2023. The same timetable applies to the neonatal care leave and pay bill, and that will allow parents whose babies need hospital neonatal care to take 12 weeks paid leave in addition to their statutory maternity or paternity leave. And that right will be available from day one of employment. It will apply to parents whose babies are admitted to hospital up to the age of 28 days, and it will apply to babies who need to stay in hospital for 7 days continuously or more. The carers leave bill is next. Again, no date for implementation as yet, but I think that's also receiving its third reading in February. This will entitle unpaid carers to 1 week of unpaid leave a year to care for a dependent with a long-term care need. Employees taking their carers leave entitlement will be subject to the same sorts of protections that are already associated with the various forms of family-related leave, meaning that they'll be protected from dismissal or detriment as a result of having taken that leave. Next, the Pregnancy and Maternity Redundancy Protection Bill. Well, currently, of course, as you probably know, employees on maternity leave must be given priority for suitable alternative employment in a redundancy situation. And the broad effect of this bill will be to start that protection sooner. So that will be from the moment that an expectant mother or an adoptee of a child or someone taking shared parental leave notifies their employer of the pregnancy, and it will last until either for 18 months or 12 months after the end of the maternity leave or such other parental leave that the person has taken. Again, no date for implementation of that as yet, but it's in the pipeline. Next is the right to request flexible working from the first day of an employee's job. So a day one right, which is moving towards this default entitlement to flexible working. It will make it possible for 2 flexible working requests to be made in any 12-month period. So currently it's just 1. And employers will have to respond to the request in a 2-month period. So that's down from the current 3-month period. Consultation closed on that on the 1st of December 2021. The committee stage of that was yesterday, so that's before the 3rd reading stage. So that's slightly behind in its scheduling than the rights I've mentioned above. Next, something to expect is a new statutory code on fire and rehire practices. So that's a practice that will hit the news more recently because of things like the P&O dispute, which actually wasn't a fire and rehire, that was a fire and then they used third-party agency workers, but there's been other issues with Maid and Jules. But it's reignited that debate, this process where employers dismiss employees and offer re-engagement, but often on less favourable terms. It's not usually illegal, depending on how it's done. It's usually the last resort in sort of redundancy type situations or changing terms situations. But this is about introducing a code of practice which will, I suppose, re-emphasise the issues around consultation. But importantly, much like the codes in relation to discipline and grievance, it will be a code which tribunals will be required to take into account, and tribunals will also be able to apply an uplift of up to 25% to an employee's compensation where the code applies, but the employer unreasonably fails to follow it. So we're still waiting for publication on that, and when we know more about that, then obviously we'll let you know either in bulletins or future HR breakfasts. Corporate governance reforms for listed companies and large private companies. So here the government's consulted on audit and corporate governance reforms. And that would include new directors' duties relating to risk management and proposals to claw back directors' bonuses if the company collapses or there are serious director failings within 2 years of the bonus payment. I think it's often the case that people become directors and they're not entirely aware of the various duties and responsibilities that come with that. So this is something which is only at consultation stage. But it is an area that, I mean, and this is a bit of a sales pitch, where our corporate team provide training on that. It's something that I think that businesses and particularly directors should be getting trained on now. We offer a package on that. I know it costs less than £1,000, and that would get directors trained up on all of their duties. So that's something I think that businesses and directors in particular should be considering carefully. Next. And this is a bit further down in terms of the pipeline. This is the issue of menopause and its prospect of being treated as a protected characteristic. So back in July 2021, the Women and Equalities Committee launched an inquiry into current legislation and workplace practices in relation to the menopause. And in 2022, so then a year later, in July, the committee published a report, and one of the recommendations was that the government should consult on introducing menopause as a protected characteristic. It is a growing area, it's one to look out for. Lots of businesses are already acting, not waiting for that to happen. And then the last in my update is not sort of legislation, but it's a case which is due to be heard shortly on the 14th and 15th of December. It's a case that's been heard in the Supreme Court. One of the Chief Constable of the Police Service of Northern Ireland and Agnew, and that's will be a decision as to whether a gap of more than 3 months in a series of unlawful deductions from holiday pay will break the series of deductions. So we'll be looking out for that, and those of you who already signed up to our employment bulletin. We'll be writing about that in the next edition of that once the decision has been, or maybe not in the next edition, but once the decision has been issued. And I'm going to go and have a lie down now, and I'm going to hand over to Jake, who's going to take you through the case law update.
Thanks, Kevin, and good morning, everyone. So the first case we're going to look at today is Morgan and Buckinghamshire Council, and this case relates to a claim brought by an employee for discrimination arising from her disability. So the facts of this case are that the claimant was working as a supervising social worker in the council's fostering team. She's autistic, and it's important to note here that the council accepted that the claimant was disabled in the legal sense due to her autism, so this was not challenged at any point in the case. During the course of her employment, it came to light that the claimant had been given Christmas presents to a child for whom she was caring for without getting the appropriate authorisation first, and this happened on more than one occasion. This was actually a breach of the council's code of conduct, which set out risks of giving gifts to children under care, especially as doing so could be misinterpreted by others as being a gesture either to bribe or groom a child. The claimant had also written inappropriate content in a case note that she had recorded following a meeting with that same child, and the case note was considered by council to be inappropriate and unprofessional, as it consisted mostly of her own thoughts and feelings rather than accounting for the meeting with that child. Unsurprisingly, the claimant was subject to a disciplinary process, and the council then dismissed her due to her conduct. The council justified her dismissal by saying that the claimant could not be trusted to not breach the council's code of conduct again. The claimant unsuccessfully appealed her dismissal, and in the appeal decision, the appeal officers stated that it was a matter of serious concern that she had chosen to hide her autism by masking her condition throughout much of her employment, potentially putting vulnerable children at risk. So she brought a number of claims in the employment tribunal, and those are being unfair dismissal, disability discrimination, and harassment. The claimant's primary case was that if she was dismissed for misconduct, then that dismissal arose in consequence of her disability, and the dismissal was not a proportionate means of achieving a legitimate aim. Those consequences that she relied on included cognitive impairment, stress, and emotional vulnerability. She also claims that the comments made by the appeals officer that she was masking her autism and acting deceitfully amounted to an act of harassment relating to her disability. The employment tribunal found that the claimant's dismissal was fair, and the council had acted fairly by not trusting that the claimant would not breach their code of conduct again. It also found that she had not been subjected to discrimination arising from her disability because the council had managed to justify her dismissal. However, her claim for harassment was successful. The tribunal did not agree that the claimant hid her autism, rather that she had learned behaviours that led her to masking her condition, and it was therefore offensive to suggest that she'd been acting deceitfully. The claimant appealed to the Employment Appeals Tribunal, the EAT, and the council cross-appealed the harassment decision. Both the appeal and the cross-appeal were unsuccessful. The EAT upheld the tribunal's decision that the dismissal of the claimant was fair and justified, and just like the tribunal, the EAT held that the claimant had breached professional boundaries and the council could not be confident that she would not do so again. They agreed with the council that a written warning would not be enough. Also, the EAT acknowledged that the claimant herself knew that she needed proper authority for giving presents, and I think crucially, the claimant knew that she could be dismissed if she didn't get that authorisation first. In terms of the appeal for the harassment claim, the EAT commented that although the appeal officer's comment was only one single comment, it was still a considered observation in a formal letter, and that was enough. So what does this mean for employers? Well, first of all, it's always important to remember that neurodivergent conditions such as autism can actually be a disability, and therefore if an employee is treated unfavourably due to their condition, that could give rise to a claim. It's worth also pointing out that neurodiverse related tribunal claims are on the rise, and in fact they've risen by about a third in the last year. So for this reason, it's important to remember that some disabilities are hidden. This case is also a useful reminder to employers that an employee's disability may impact on their conduct and their performance at work. So because of this, An employer should always take a disability into consideration when looking at what action to take in relation to performance and conduct issues. It may seem obvious, but if a disability is involved, then an employer must think about the impact of the disability and justify any disciplinary action or dismissal. And I think what's interesting about this case is that the council showed that the employee was likely to breach their code of conduct again. So it's worth considering the likelihood of conduct recurring, and if misconduct is likely to happen again, then an employer can be justified to move straight to dismissal rather than a written warning. And finally, managers should be careful not to criticise employees for adopting strategies to help them cope with their conditions. So, for example, in this case, with the claimant doing behaviours which hid her autism. So the second case we're looking at today is the case of Hilaire and Luton Borough Council, which is a case relating to redundancy. So the facts of this case are that the claimant worked at the youth support department at the council. Unfortunately, a redundancy situation arose, and part of this involved restructuring the department. I think it's important to note here that the claimant suffered with depression, which impacted his day-to-day activities. So, for example, he was really fatigued, lacked motivation, and had problems with memory and concentration. As part of the redundancy process, employees were asked to apply for a new role in the new work structure. However, the claimant found this application stage difficult due to his depression and those associated symptoms. The claimant told his manager that he was not given enough support whilst he was absent from work due to his depression during the consultation in the redundancy process. And as a result, he was given an extension to submit his application form of 11 days. He also received some support to complete the application. The claimant was invited to an interview. However, he refused to attend because he was off sick. The council delayed the process to give him time to return. However, the claimant refused to attend any further interviews. So the council considered whether there was another way of dealing with his application that didn't involve an interview. However, they felt it would not be fair on other employees and the treatment would not be consistent. The council also thought that he would be selected for redundancy anyway, based on his sickness absence record. So the council weren't willing to delay the process any further, and the claimant was therefore made redundant. So then the claimant brought a number of claims to the Employment Tribunal, including the employer's failure to make reasonable adjustments in relation to his disability. Firstly, the tribunal found that the claimant was disabled due to his depression. So that means they found that his depression had a substantial and adverse impact on his ability to carry out day-to-day activities. The tribunal then considered whether the claimant was put at a disadvantage due to his depression and whether there are any adjustments the council could have made other than delaying the interview. The tribunal held that the council applied a provision, criterion, or practice by requiring him to attend the interview. However, the tribunal found that the claimant was not placed at a disadvantage by it, because the council was able to provide evidence showing that the claimant did not ever intend to engage with the redundancy process, nor was he ever actually going to attend an interview. And that's because the claimant had actually admitted that he would not have attended the interview, even if he wasn't off sick, because he thought that the council just wanted to get rid of him, and therefore the redundancy was just a disguise. And obviously those reasons didn't relate to his disability, and therefore the claim failed. So the claimant appealed this decision to the EAT. First of all, the tribunal made an error when deciding if the claimant was placed at a disadvantage. The tribunal considered whether the claimant was capable of attending the interview. What they should have done was look at the effect of his disability and whether that effect made it more difficult for him to attend the interview, which did seem to be the case here. However, the EAT agreed with the tribunal that the cause of the disadvantage was not the disability, but the claimant's refusal to attend the interview for reasons not relating to his depression. The appeal therefore failed for this reason alone. And in terms of making adjustments, the EAT pointed out that the claimant's condition was severe enough that a short delay to the process would not alleviate any disadvantage that he was experiencing. However, a longer delay would not have been reasonable, given it was a collective redundancy. Also, the council couldn't have just slotted the claimant into a role without an interview either, which is what he suggested, as this would have been unfair to other employees. The EAT stated, and I quote, that making an adjustment is not a vehicle for giving any advantage over and above removing the particular disadvantage. In this case, just slotting the claimant into a new role would not have been reasonable, and therefore the council was not found to have discriminated against the claimant, by failing to slot him into the new vacancy, and therefore the appeal failed. So what can we take away from this case? Well, first of all, the case reminds us that whilst an employer has a duty to make reasonable adjustments for disabled employees, that adjustment must not go above and beyond what the adjustment is intended to do. So basically, it can't put the employee at an advantage over other employees. The whole point of a reasonable adjustment is to create equality in the workplace. So clearly, they should not be putting a disabled employee at an advantage over others. The case also reminds us that when making a reasonable adjustment, an employer should consider the wider impact it may have on the business. So, for example, here the redundancy process was time pressured, and it wouldn't have been reasonable to delay the process indefinitely for the claimant due to the impacts that it would have had on the business and other employees. Finally, this case shows that for an adjustment to satisfy the legal test, it has to actually alleviate the disadvantage that a disabled employee is experiencing. Basically, an employer can't just make a load of adjustments. They have to assure that they're actually working, otherwise the definition of reasonable adjustment has not been met. In this case, the additional time that the council gave to the claimant was not actually reasonable adjustment because the claimant's condition was so bad that it made no difference. Employers should therefore make sure that a proposed adjustment will actually benefit the employee. So those are your two case updates for today. I'll now hand you over to Claire.
Thanks for that, Jake. So carrying on with the theme of redundancy. So sorry, it's not the most cheery of subjects, but the HR hotspot, we've decided to focus on redundancy and what procedure to follow. The reason for this really being is because, as we all know from the news, inflation has reached its highest in the UK for 41 years. And unfortunately, this obviously combined with the energy crisis is already having a big impact on many businesses, which may mean when planning for the future, you unfortunately might have to think about planning for potential redundancies. So ACAS have actually recently said that nearly 1 in 5 employers are considering making staff redundancies over the next year. So the purpose of this part of the webinar is therefore to hopefully help you as business owners and individuals responsible for HR to plan for this if it's something your business is considering either now or in the future. Whilst there's no doubt that redundancies are usually a very effective cost-cutting exercise, if they are not done correctly, then they can actually have the opposite effect and end up costing you more than the redundancies were saving. And the reason they can be so costly is because if you get them wrong, there's obviously potential claims. So, for example, we've got a potential unfair dismissal claim for employees with over 2 years service, discrimination claims, which can be pursued rather by employees irrespective of their length of service. And then there's also an additional claim available to employees if you have made large-scale redundancies and not followed the correct process. So by large-scale redundancies, I mean when you're making 20 or more. And this additional claim is it's for what's called the protective award, but I'll go into that in a bit more detail further on into the presentation. So how to carry out a fair redundancy process so that you can avoid these claims? Well, the key really is planning from the outset. So we do see, or we often see employers making a decision far too quickly about which employees will be made redundant. And if you do this, then this will render any process that you then follow unfair. So then there's consulting about the proposed redundancy. So you might have heard about this term or heard of this term before. And this is because in any fair redundancy process, it's necessary that you consult with the employees whose roles you have identified as being at risk of redundancy to see if there's any way that it can be avoided. But what is consulting? Well, ACAS define consulting as a talk with employees and representatives about planned changes, whilst also seeking their views and input. So practically, this means meeting with employees or their representatives to have open discussions with them about the proposed redundancies to see if there is any way they can be avoided. So it's really is key that you go into a consultation with an open mind. The decision to dismiss or make redundant cannot already have been made. And as an employer, you must be capable of having any decisions influenced. So who should you consult with? So again, I will go into this in a bit more detail further into the presentation, but if you are proposing to make 20 or more employees redundant at one establishment over a 90-day period, you are under a duty to collectively consult. So what that means in terms of who you consult with is that you have to appoint employee representatives who you will consult with on behalf of the employees. However, if you've got less than 20 employees at risk of redundancy, then you would consult directly with each employee who is at risk. And then how long should the consultation last for? So when planning for the redundancy process, it's crucial that you allow enough time to enable the consultation to take place. If you are making less than 20 employees redundant, then the law doesn't state how long you should consult for. Commonly, though, I would say that we see a consultation period of around 2 weeks, depending on the number of staff at risk of redundancy and what happens during that process. It's usually a fine line between not rushing the consultation so as to undermine fairness, but not allowing it to drag on too long so that it's hanging over both the staff and the business. The key then here really is to be flexible with your process. So if employees have had a lot of valid points to make during the consultation, you will no doubt need longer to consider these and maybe make changes to your selection criteria and maybe even have additional meetings than you had initially planned for. It's difficult to see that if you do end up extending it, I can't imagine a situation where you would be criticised for having done that if there was valid reasons to do it. So if I just move on to the next slide, carrying on the theme of consultation. So what should you consult about? So first things first, ordinarily you're going to want to consult about why you are making redundancies so that the employees understand this. Secondly, the pool of employees who are at risk of redundancy. So, for example, do you have 3 receptionists that you need to reduce down to 1, or do you have 10 front of house staff that you need to reduce down to 5? It's important that the employees are clear on who else is at risk of redundancy so that they can challenge their appropriateness to be included in the pool. So, for example, if you have got a front of house member of staff who also does some shifts where they work back of house, they may state they shouldn't be at risk of redundancy, and you'll need to consider this as part of the consultation. Then there's the selection criteria. So it will be necessary where there are multiple redundancies to consult about the selection criteria. Because if, for example, you are reducing your receptionist down from 3 to 1, how are you going to decide which 2 are going to be made redundant? Well, the way to do this is by having a fair selection criteria to score the employees against, so that those with the lowest are then made redundant. So, for example, in your selection criteria, will you consider absences, the performance reviews, any disciplinaries? But I guess it's just really important to note, though, that when you are considering your selection criteria, that you do give a lot of care to it, because whilst it is possible to have subjective selection criteria, it's generally always better to have objective selection criteria to avoid potential discrimination claims. So one case that's been reported quite recently on this point was a successful disability discrimination claim, which was pursued by a dyslexic employee that was made redundant, and it was pursued against Marks and Spencer's. So she pursued it based on, so she was made redundant based on her ability to communicate and express her thoughts in email. And this was because the selection criteria that Marks and Spencer's used was based on the employee's behaviour, technical skills and leadership skills. And on the behaviour criteria, this particular employee was marked down due to the tone of her emails. And during the consultation, though, this employee said, but this is an area I find particularly hard, drafting emails, and that's because of my dyslexia. And surprisingly, Marks and Spencer's were already well aware of this, though, because her manager actually checked a lot of her important emails before they were sent because of the difficulties she had drafting them. So in the Marks and Spencer's case, the tribunal found that their selection criteria did discriminate against the employee on the grounds of dyslexia, of her dyslexia, because they made no adjustments whatsoever to the selection criteria and to her scores to take account of the difficulties she faced. And the tribunal also noted that the selection criteria was actually completely unfair because it made it very difficult for the managers using it, so the managers doing the scoring, to apply the criteria fairly and objectively because they contain no purely objective elements. So as a result of this, M&S were ordered to pay the employee £53,000. So the judgment really does go to show that when considering the appropriate selection criteria, it is vitally important to think about who the employees are that are at risk of redundancy, and in particular, whether any of them have disabilities, and if they do, what adjustments might be necessary to ensure they aren't put at a disadvantage because of that. So if I move on from that and discuss ways to avoid redundancies, so yes, that's something that definitely needs to be spoken about during the consultation. So you need to obviously think of your own or have your own methods for avoiding redundancy that you can suggest to staff, but also take on board any suggestions that the staff might have. So, for example, does anybody want to take voluntary redundancy? Could you agree to reducing hours? Or are there vacancies at another site or another role which the employee could potentially apply for and take in order to avoid their redundancy? And then finally on this slide, suitable alternative employment. So this is an ongoing duty during a consultation process. So, for example, if you do have multiple sites and there is a vacancy at that site, or you have a vacancy in another suitable role, you will need to discuss this with the staff or their representatives, as it may be that, again, this could be a way of avoiding their redundancy. So broadly, very broadly speaking, that's what a fair redundancy process looks like. But if you are proposing to make large-scale redundancies, then additional obligations apply because collective consultation duties are triggered. So if I just move to the next slide to explain what I mean by large-scale redundancies which trigger collective consultation duties. This is, as it says on the slide, where employers are planning to make between 20 and 99 staff redundant at a single establishment within a 90-day period, then they must consult for at least 30 days. Or where employers are planning to make 100 or more staff redundant at a single establishment within a 90-day period, then they must consult for at least 45 days. So, for example, if you are a bar operator and you have multiple sites, if you have 20 or more members of staff at one site and you unfortunately needed to close that site or reduce the numbers beyond 19, then you would need to collectively consult with these staff for either a minimum of 30 or 45 days, depending on the number of staff that we're talking about. Whereas if actually you employ less than 20 staff at the site you were closing, but you have more staff at your other sites, provided you are only closing the sites with less than 20 members of staff, these collective consultation obligations that I'm going to go through won't kick in. So just before I move on from this slide, it is just worth me pointing out, though, that redundancy in the context of collective consultation has a much wider meaning than redundancy when there are less than 20 members of staff. And that's because it doesn't just mean where there is a disappearing job or a disappearing workplace. It also means if a business is seeking to change 20 or more employees' terms and conditions. So, for example, if you wanted to change the hours or overtime rates applicable to staff, then collective consultation duties would be triggered. So in addition to the timeframes on this slide, there are other things that you need to follow, or other duties, I should say, in collective consultation. The first being the election of appropriate representatives. So in collective consultation, representatives should be consulted with on behalf of all the employees. If your business recognises a trade union, then it will be the trade union rep. But if not, then you will need to allow your employees to elect representatives within the workforce. And the 30 or 45-day consultation period is not triggered until the representatives have been elected and you're ready to start consulting with them. So it's even more crucial in collective consultation that you plan the process well in advance, as depending on the number of representatives you need and the number of employees who put themselves up for election, this process can take time. So there's no rule though about what number of representatives you should have. The key though is that staff are fairly represented. So if, for example, you have chefs, bar staff, waiting staff being made redundant, then it would definitely make sense to have at least one representative from each of these roles. And then, the second bullet point, providing written statutory information. So in collective consultation, there is very specific written information that must be provided to the representatives. So, for example, the number and description of employees who you propose to make redundant. And then there's also the obligation to notify the Secretary of State. So this is basically done via a form. The form's called the HR1 form, and that needs to be completed and submitted within the consultation period so that they're aware of the number of redundancies which you're proposing. So hopefully you can see there with collective consultation that there are more stringent requirements that you need to follow. There's the 30 or 45-day minimum consultation period, the election of appropriate representatives, and providing the written or the specified written information and completing the relevant forms so that you can notify the Secretary of State. So what happens if you get the redundancy process wrong? Well, as I said at the beginning, there's obviously the potential of claims. So there's an unfair dismissal claim, as I said, for employees with more than 2 years service. The award for successful unfair dismissal claims is predominantly based on employees' financial losses, so how long it takes for them to find new work. Therefore, if the job market does change and it becomes harder to find new work, then the value of an unfair dismissal claim is going to increase. Then there's the protective award, which is unique to collective consultation. So irrespective of an employee's length of service, if you were supposed to collectively consult and you either didn't or you didn't do it properly, then the employees would be entitled to make a claim for what's called the protective award, which is up to 90 days gross pay for each employee. And so it is one of the more expensive employment claims. Then there's fines, again, which are unique to collective consultation. So if you fail to complete the correct form I mentioned to submit to the Secretary of State, then this is considered a criminal offence, and so it is subject to the appropriate fines. And then discrimination claims. So this is an area I would say that we are seeing more of, as shown by the cases that Jake spoke about. It's a claim. We usually tend to see discrimination claims in the context of redundancy about the selection criteria that's used, so a bit like the McManus example I spoke about earlier as well. And then finally, the reputational damage, which is always a risk in any type of litigation, just because tribunal judgments are public documents, so they are available on the tribunal website. So if I finally just speak about the redundancy support that we can help with to avoid these claims. So we've created a package that is insurance backed, so that if there were tribunal claims, the insurer would pick up the tab in relation to the legal fees and any award given to the employee bringing the claim. What that means is that we can fix the legal costs for advising you through the redundancy process and fix the insurance premium costs as well. You might though think, well, if you're getting legal advice throughout the redundancy process, well, why would there be a tribunal claim? And I completely get that. And whilst we would definitely hope that our help would basically decrease the chance of you getting any claims, as staff should be able to see and understand that you have followed a thorough, I should say, and fair process. We can't obviously guarantee that employees won't bring claims, because they might think, well, they've got nothing to lose basically by doing that. And what we really, I guess, have have seen is that when the job market is less buoyant, this happens more because employees basically, as I say, think they've got nothing to lose and there are no fees to lodge a claim at an employment tribunal. So it's very easy for them to do that. Similarly, we help clients with redundancy situations outside of the fixed cost insurance-based support package. So it might be that you want advice at different stages of a redundancy process, and that's fine, or just with the documentation that's needed. or you want the full support but without the insurance. And that's absolutely fine. That is something we help clients with. We are a team of 9 employment lawyers, and so we have the capacity and expertise to tailor our advice to what you need. And it might actually be that as a business you want to go down the settlement agreement route by paying employees an enhanced redundancy payment, and that will enable you to avoid the need to carry out a full redundancy process and obviously reduce the risk of a claim, in which case we can support with that. Or if we aren't already a client, then and you need a reputable independent firm of solicitors to provide advice to your staff on bulk settlement agreements, then again, that's something we can help with, because we do act for employers and employees. So that's everything that I wanted to say on the HR hotspot. So I'll pass over to Kevin to and deal with any questions and bring the webinar to a close.
Yeah, well, I might not be keeping you too long with questions. We've just got one question so far, but then there's still some time if you wanted to type them up. If you want, I won't read your name out of whoever's asked the question. Here is quite a candid question, though. We're asked, what is the going rate for advising on settlement agreements these days? That's a good question. So when I started my training contract in 1996, the going rate then was £250, and I think that some would say that it's still £250. So it would be rare that you'd see it at less than that, but it's probably more common now that the going rate, particularly since a case maybe about 3 or 4, perhaps even longer ago. Okay, there was a case of Solomon a few years ago where the EAT commented on that and said, made an indication that fees on settlement agreements should be £500 for advising on the terms rather than negotiating them. So I guess, and then it depends on the circumstances. It can go up from there, but I would say it probably gravitates more around £500. Now, I think that there may be the only other caveat to that is possibly because of the size of our team, there will be situations where we're asked to advise on large numbers of settlement agreements, perhaps when there are hundreds of people that have been proposed settlement agreements, and then in those situations, then often because you're advising fundamentally on the same agreement, although people's circumstances are different, then the fees for that would certainly reduce. Or can reduce depending on the circumstances. So that's a good question. I hope that's a candid answer. I don't think that there are any other questions. So Claire and Jake, you've been spared there. So I suppose the only other things then to mention in signing off is to let you know that our next HR breakfast will be in March. We'll give you further details of that by email. There is a question that's just come in as well, but I'll come to that in a moment. In fact, let me deal with that now. So apologies if you've covered this, but we're looking to reduce breaks for our staff, approximately 80 employees. They usually work 8-hour shifts, and for years have had 2 other paid breaks for 25 minutes. Do we need to consult and serve notice? I don't know whether you want to start on that, Claire, or you want me to start and you can chip in.
Happy for you to start, Kevin.
It's a period of giving, isn't it? So thank you.
It is.
So I suppose if they've the starting point, I suppose, is to establish whether or not something is contractual. and there are lots of different ways of establishing whether something is contractual, and most commonly the starting point would be to look at the terms of the contract. And so if they usually work an 8-hour shift and they've had 2 other paid breaks of 25 minutes and you're trying to reduce them, and sorry, it is contractual. I'm getting live updates. This is great. So if it is contractual, then yes, you should consult on that. If you're making a variation to someone's contract, then you the starting point is you should be seeking to agree that variation. If the variation is agreed, then you should get that documented, reissue either side letters or new terms. And if it's not agreed, then you need to start consulting and going through the steps which Claire talked about on collective consultation because of the numbers of people that you're talking about. So you've got 80 employees, so you hit that threshold, all of those collective consultation requirements kick in. And so, yeah, you should consult. You should not do anything like a P&O type thing and send people texts or recorded messages so that they're told that their employment is terminated and give them notice and that they're re-engaged on the new terms. Although that sort of thing can still be a last resort if you've gone through the proper consultation processes. Anything to add to that, Claire? Or even Jake? No?
No, good.
No, okay, good. So hopefully that answers that question. So I mentioned the next HR breakfast. We've had good coverage, I suppose, from doing these online, so we're going to maintain them online, but we also miss, and maybe some of you might also miss, the HR breakfast or the events that we used to do live. So next year we will be returning to some live events. The proposal that we have is that we're going to do some HR roundtable events. So they're going to be limited numbers, probably to numbers of about 15. They'll take place at our offices at Blackfriars House on the parsonage. So there'll be roundtable discussions where we'll get to see you again in person and discuss key events. If that's something that you'd like to be involved in the future, then you've got contact details. You've been inundated with contact details slides. So get in touch and let us know. It would be great to engage on a face-to-face basis with people in the future. I think that probably brings our event to a close for the morning. Thank you very much. I'm assuming that there are people out there listening to this. There's certainly one person that asked me a question, or two people out there asking me questions. So yeah, I hope that you've enjoyed the session. If you've got feedback on what might make them better, then please email us. And otherwise, have a great day, a great Christmas, and we hope to see you all soon. Thanks.